Court proceedings have started in East London with regards to the ANC's Eastern Cape PEC and those issues there. Let's go live.
The branches which the applicants purport to represent in this matter were fully determined and finalised. Underpinning this relief, the applicants complained that the steering committee of the ANC had unlawfully forged ahead with the conference, which had commenced on 29 September 2017, without first, quote, investigating or hearing their grievances and appeals, unquote. They alleged that this conduct was unlawful and unconstitutional and failed to be set aside ultimately on review. The applicants had hoped to secure an interim order on the basis proposed without giving the respondents notice, but I was not prepared to entertain the matter on an ex parte basis. Instead, I issued a directive which was forwarded by email to the applicant's instructing attorney, Mr. Nochesi, at 28:49 on Saturday evening in the following terms. 1. The registrar may issue the proposed application tonight with the matter to be heard at 8:30 a.m. tomorrow. 2. Proper notice must be given to the respondents in whatever manner is possible between now and the hearing. 3. The notice of motion must be amended to comply with the demands of the matter. In other words, it should direct the time periods relevant to the proposed hearing within which notices to oppose and opposing papers should be filed. You should also consider that no relief of a permanent nature can be undertaken under these time constraints. Indicate what limited immediate interim relief is to be sought and separate out the other issues to be dealt with in the normal course. Paragraph 4 is irrelevant for present purposes. Since the applicant's papers had already been prepared and only a minor amendment to the notice of motion had been proposed by my directive, I expected that the registrar, who was on standby, would promptly issue out the application, leaving the respondents at least 10 hours or so after service of them at the conference to file their opposing papers, however brief. Indeed, I was informed by her at 21H31 that the applicant's representative had made contact with her and had indicated that he would be there within 10 minutes. When the matter served before me on Sunday, 1 October 2017 at 8:30 a.m., there was initially no appearance for the respondents, but I was informed by my clerk that Mr. Bodlani, who appeared together with Mr. Mchabe for the 3rd, 4th, 36th, 38th and 39th respondents, was on his way to court to oppose the application. I also learned that the registrar, who had placed herself at the disposal of the applicant's instructing attorney to issue out the application at his prompting, had waited throughout the night, but to no avail, until she was called back at 4H20 on 1 October 2017, finally, to open a file and to allocate a case number. It is common cause that the papers were thereafter served on the then Provincial Secretary of the ANC, Mr. Oscar Mabuyane, who apparently accepted service on behalf of all the respondents between the hours of 6 and 7 a.m., rendering nugatory the intimation in the applicant's notice of motion that if they wish to oppose the application, they should deliver such notice by 5:30 a.m. and their answering affidavits by 6 a.m. It is not surprising that Mr. Sakela, standing in for Mr. Bodlani, who was en route to East London at that stage, requested time to obtain instructions and to prepare opposing affidavits. As a result, I stood the matter down until 2 p.m. When the matter was argued before me at this time, the applicant's instructing attorney, Mr. Nochesi, put up an affidavit dealing with the manner of service. He explained that the sheriff was unavailable and that the police had refused to assist, resulted in him personally serving the papers on Mr. Mabuyane. His evidence was not challenged in this regard, and I accept that this delay between the hours of 4:30 a.m. and 7 a.m. was beyond the control of the applicants. What is not accounted for, however, are the hours between the emailing of my directive to Mr. Nochesi and the issue of the application in the early hours of the morning. Mr. Mneno, who appeared for the applicants, tried to persuade me from the bar that there had been some incident on the road from Mthatha which played a role in the time lost, but this was not explained in any detail so that the circumstances could be fully appreciated or the motives of the applicants assessed. Neither did they seek condemnation for their failure to comply with my directive or apply for any extension of time to enable them to meet the supposed exigencies of the matter, leading to the ineluctable conclusion that they had hoped to frustrate the rights of the respondent to receive reasonable notice of the application. The applicants appear to have missed the plain objective of my directive, which was to ensure that, notwithstanding the very tight time constraints, the respondent should not be taken by surprise and at least have an opportunity to prepare a brief response. If their failure to issue out the application promptly was not deliberate, they acquiesced, in my view, in losing the supposed urgency of the matter. Counsel for the respondents contended that this lackadaisical approach was fatal to the application on the issue of urgency. I am inclined to agree. Against the applicant's assertion that the matter was one of, quote, extreme urgency, unquote, I find it unacceptable that, upon being given leave to forthwith issue out the application on Saturday night, they then dallied while the conference, which they had hoped to interdict, continued. As it turned out, after I issued the directive, the business of the conference continued through the night and had, according to the brief answering affidavit of Mr. Maboyane, concluded by the time the matter was argued before me. Not unexpectedly, counsel for the respondents submitted that apart from the short notice and the drastic abridgment of the rules of court, this rendered the interim relief sought by the applicants entirely academic. Mr. Moneno unconvincingly sought to persuade me to the contrary, that the conference was in fact still underway at the time of the hearing, on the simple basis that it was scheduled to carry on until the end of the day on 1 October 2017, and that the relief sought was in that sense still competent. But I cannot ignore the respondents' allegations in this regard. Indeed, not only did the respondents clarify that the business of the conference, which was the harm in essence the applicants sought to interdict from happening before their grievance and appeals were dealt with, but added that the elections had culminated in certain decisions being taken which significantly altered the premise of the applicant's case, resulting, for example, in a change of personnel in the portfolios of the PEC, of the ANC in the province, so that those cited in certain specified capacities no longer hold such positions. Without determining the impact these decisions posed to the applicant's case, I agree with the respondents that these changes signify the stage to which the conference sought to be interdicted had progressed and advanced by the time the matter was argued before me at 2 p.m. The fact that the conference was still extant when I issued my directive, despite it being over when the matter was argued before me on 1 October 2017, is not an argument that redounds to the applicant's benefit either. This is because they missed the opportunity to enroll the matter in accordance with my directive, allowing for the abridgment of the rules concerning form and service under the peculiar circumstances. In the result, the application was not properly enrolled and forced to be struck out, it being trite law that where a court finds a lack of urgency, this is the appropriate order to be granted. Of course, that is not to say that the applicants have lost their right to challenge the alleged illegality of the conference in due course by virtue of the fact that the formalities have brought the conference to an end, but self-evidently the entire premise upon which the remedy of an interim interdict rested has fallen away. Mr. Moneno appeared reluctant to concede that a review was possibly the only way forward for the applicants now, assuming for present purposes that there is merit in the allegations that they were denied the right to have their appeals and grievances dealt with and that certain delegates were not accredited, etc. As an aside, although the respondents reserved their rights to deal with the merits of the purported case against them under different circumstances not driven by urgency, they in broad terms deny that the applicants' appeals presented during the conference were not heard fairly or that they were not given an opportunity to present their cases. They claim that each grievance was examined and a finding made per case presented. So too they deny that any of the delegates attending the conference were not properly accredited members in good standing of the ANC. They plead that the conference proceeded because all the constitutional requirements for a valid conference were met. It is unnecessary for me to decide the merits of the application because of the view taken above that a case for present urgency is not made out. It is evident, however, in any event, that a clear dispute of fact exists between the parties concerning the applicant's supposed complaints of material irregularities warranting the discontinuation of the conference on the applicant's version. This goes to the heart of whether the applicant's accepted right of participation in the conference were infringed under the circumstances. In this regard, and taking into account the test to establish the prima facie right, where there are conflicting versions on this issue referred to in Webster versus Mitchell and clarified in the matter of Gould versus Minister of Justice and another, the version put forward by the respondents that there was no breach of the applicant's rights as alleged by them, not controverted at all by the applicants, cannot be simply dismissed as offering up a mere contradiction or an unconvincing explanation. On the contrary, serious doubt is thrown on the applicant's purported protectable interest. In the result, and for the reasons already indicated, the application falls to be struck off the roll, given that it was not properly enrolled before me, and the respondent's rights compromised by the applicant's failure to adhere to my directive, given recognition to their right to be properly heard under the relevant and very pressed circumstances. The costs must follow that result. I'm mindful that the applicants may wish to still pursue a review. Since they have gone to the trouble to set out the basis for it in the present application, I'm inclined to allow them to make out their case on these papers suitably amended, should they wish to avoid a duplication of costs by later issuing out a fresh application. The order I intend to make accordingly takes account of this contingency. I issue the following order. 1. The urgent application for interim relief is struck from the roll. 2. The applicants are to pay the respondent's costs, such costs to include the costs of to counsel. And 3. The applicants are granted leave to use the same papers suitably amended to pursue an application for review, if so advised. If anybody requires a written copy of the judgment, please furnish your email particulars to my clerk, Ms. Frost, and it will be forwarded to you by email.